Thanks.
Thank you.
Thank you.
And if we can we are just waiting for one of our guests, and I believe he should be here in another 7 minutes, and then we are good to go.
Perfect. Yeah. And can you hear us well enough?
Yes, loud and clear.
Okay.
I wish to ask the same for my ears.
Yes, it's good. It's maybe not super loud, but it's loud and clear. Can you hear us well enough?
Yes, loud and clear.
Ja, ist ja was.
Just before we begin with the session, I wish to ask if the panelists would like the questions to be taken as we proceed, or should we reserve it for the end of the session?
I have no
Either
strong
way.
preference.
Yeah, same here. Sorry for the interruption. Either way works for me. Thank you.
Did you mean the questions from the audience, Arijit? You're on mute.
Yeah,
Yes,
same here.
that's what I meant.
Either way works for me.
In the end, it's better. I don't care.
Yeah, actually, we don't care.
They can ask whenever they want.
Yes, so just waiting for our guests, and I just messaged him. He'll be here in another 5 minutes.
So,
Maybe should be the camera.
Yes, we have the complete panel here. Good afternoon, sir. Thank you so much for joining us. With this, firstly, very good afternoon to each one of you for agreeing to be a part of this international panel discussion organized by our university, Bharati Vidyapeeth, deemed to be University Pune, India. And before we commence the session, I would like to invite our co-moderator and anchor, Anisha, so that she can briefly introduce the guests for each one of our attendees who have joined us through the YouTube live. So Anisha, on to you, if you may.
Yes, am I fairly audible? Dear Excellencies, distinguished guests, dear students, ladies and gentlemen. My name is Anisha Arya, and it is an immense pleasure of mine to warmly welcome you all to the second panel discussion of day one of the first edition of our International Panel Discussion 2022, presented by the Bharatiya Vidyapeeth, deemed to be University, New Law Colleges, Madhya, the ADR cell. We are extremely grateful to the eminent dignitaries who have agreed to grace our event. The agenda for today's International Panel Discussion 2022 is whether dispute resolution is tilting towards investment over environment. Now it is a matter of great honor for me to welcome our Dean, Principal in Charge, Dr. Ujjwala Bindale ma'am. I request ma'am to address our panelists and our audience for the event before we commence the program.
Good afternoon, everyone. So our principal had to step out after the successful conduct of our first event. So on behalf of our beloved principal, I would further like to thank you and welcome you warmly for attending this international panel discussion. On her behalf, I would like to proceed with introducing our university as well as the Madhyastha, the ADR cell of our college, that is the Alternative Dispute Resolution cell of our college. I would begin with formally introducing our university, that is Bharatiya Vidyapeeth, to you all. The institutions of Bharatiya Vidyapeeth were accorded deemed to be status in 1996 for its academic excellence, and Bharatiya Vidyapeeth is accredited with A+ grade in 2017 by NAC and has been categorized as the first university status by UGC and is ranked 68 by the NIRF. The Bharatiya Vidyapeeth, deemed to be university, has established academic excellence and offers programs in innovative and emerging areas. Presently has 29 constituent institutions, including 3 research institutions, and is a multi-campus and multidisciplinary and is catering to the needs of urban and rural students. Today, under the excellent guidance of our beloved patrons, that is late Dr. Patanrao Kadam, the founder of our university, Dr. Vishwajit Kadam, the Pro-Vice Chancellor of our university, along with Dr. Asmita Jagtap, the Director of Bharati Medical Foundation, and Professor Dr. Manikrao Salunke, the Vice Chancellor of our university, New Law College Bharatiya Vidyapeeth has been consistently ranked among the top law institutions of India by Career 360, The Week, Lawyers Collective, India Today, Education Post, and Outlook. Last year, New Law College has been awarded with the Best Law College in India for Research and Pedagogy by IIRF Education Impact Awards. Now, I would further like to introduce you all to our Alternative Dispute Resolution Cell, that is Madhyastha. Madhyastha, the ADR cell, is a student initiative working efficiently in training and developing the skill sets of our students in the field of alternate dispute resolution by conducting various seminars, webinars, panel discussions, and inter-college competitions. Recently, the cell expanded its horizon to the cyberspace by launching a global initiative for alternate dispute resolution awareness, where the cell tried to bring the knowledge and expertise of the ADR professionals across the globe easily accessible to all the students and ADR enthusiasts in the form of blogs and videos. Today, we mark the first day of the second session of the international panel discussion, bringing together the leading experts in the field of ADR to discuss some of the contemporary issues based on the theme of international arbitration. It is my humble pleasure to welcome you all to this panel discussion. Thank you very much for agreeing to be a part of this panel discussion.
Thank you, Sanjana. This event wouldn't have been possible without the motivation and constant support of our principal, ma'am. Her guidance has always invigorated us to be the best version of ourselves. On that note, I would now move on to introducing our guests for the panel today. Firstly, Ms. Nevena Yevremovich. Ma'am brings 10 years of practical and academic experience in designing, developing, and delivering courses and training programs in international commercial law and arbitration. She also holds an LLM in international law from the University of Pittsburgh School of Law and in the civil law in the European Union from the University of Sarajevo School of Law. She is currently an honorary lecturer at the University of Aberdeen School of Law and have been a guest lecturer at various affluent universities and schools of law from around the globe. Ma'am also is a PhD candidate at the Faculty of Law at the University of Zenica, focusing on the quality of goods in CISG and SDG. She is also an author of the national monographs of the civil procedure and energy law in the volumes of International Encyclopedia of Laws. It is a pleasure to have you today with us, ma'am.
Thank you very much.
Moving on to our second guest for the day, Mr. Akshay Sridhar. Sir is an associate in Quinn Emanuel's Paris office. His practice area focuses on international arbitration, advising and representing companies, states, and state-owned entities in cross-border disputes, touching upon multiple sectors. Prior to joining the firm, Sir also trained at two boutique international arbitration law firms in Brussels and Geneva, where he assisted some of the world's most renowned arbitrators in major commercial and investor-state disputes. Other than that, Sir has also litigation and arbitration experience in India, having worked as an associate in the chambers of senior counsel, where he represented clients in construction disputes before domestic courts and tribunals. It is a pleasure to have you today with us, sir.
Thank you, Anisha.
Moving on to our next guest, Mr. Andreas Schreckenberger. Andreas is a senior associate at Gabriel Arbitration. Since 2013, Andreas has represented international businesses and organizations in a broad range of disputes with a focus on infrastructure, construction, energy, agency, pharma, insurance, banking, and human rights. Sir has acted as a counsel and administrative secretary in numerous arbitration proceedings and has also been involved in cases under ICC, LCIA, Swiss, WIAC, and ad hoc arbitration rules. He has also acted as a group advisor in Young ICCA mentoring program and is a member of the European subcommittee of the Campaign of Greener Arbitrations. It is a pleasure to have you today with us, sir.
Thank you so much, and it's a pleasure to be here.
Moving on to our second guest, Ms. Aypek Ince. Ma'am is an associate at Gedik and Erasco Attorney Partnership in Istanbul. Her practice area covers representing clients in domestic and international arbitration, as well as commercial litigation proceedings. She also advises clients on a wide range of compliance issues. She is also a member of the Chartered Institute of Arbitrators, board member of a Moot Alumni Association, and the member at the Campaign for Greener Arbitration, MENA team. It's a pleasure to have you today with us, ma'am.
Thank you so much.
Moving on to our last but not the least guest for the day, Mr. Kartikeya Mahajan. Sir is a partner in the dispute practice of Khaitan & Company. He is a US qualified lawyer and focuses on international arbitration matters, complex multi-jurisdictional litigation, and white-collar investigations. He represents clients across USA, UK, India, Singapore, Hong Kong, and Iraq, and his experience spans across private equity, energy, infrastructure and construction, telecom, and media industry. It's a pleasure to have you today with us, sir.
It's a pleasure to be here. Thank you.
Now, on that note, I would like to hand over the session to our moderators for the event, Mr. Arijit Sanyal and Ms. Sanjana Sachdev.
Thank you so much for the kind introduction and for welcoming our panelists, Anisha. My name is Arijit, and I warmly welcome you all to the International Panel Discussion 2022, organized by the Institute's Alternative Dispute Resolution Cell, Madhyasthata, and the second event in the series, titled Need for the Reset, is dispute resolution favoring investments over the environment. Before we proceed, I would like to thank our knowledge partners, CyberArb Netherlands, for their active support. Before we commence the session, I understand it is important for us and our audience who have joined us through the YouTube Live to understand the background of why we have assembled here. Our activities over the last couple of years have considerably contributed to accelerating climate change. It is against this backdrop that global leaders and stakeholders from various industries have met to discuss and to conclude various agreements on combating climate change, the most recent ones being the Paris Agreement in 2015 and the Glasgow Climate Pact in 2021. While one may assume that this may significantly aid the international investment law as far as handling environmental disputes are concerned, that has not quite been the case. This has, however, primarily been because of the states who have, in their quest of inviting investors, have reduced regulations or have refrained from using the stick. Therefore, we have assembled here to understand whether or not dispute resolution is in fact favoring investments over environment. And before we proceed, I would once again briefly introduce each one of our guests to our attendees. We have Ms. Nevena Yevremovic, who's an honorary lecturer at University of Aberdeen School of Law. We have Mr. Karthikeya Mahajan, who's a partner with the dispute resolution team at Khaitan and Company, Singapore. We have Mr. Andreas Schechenberger with us, who's a senior associate at Gabriel Arbitration, Zurich. We have Mr. Akshay Sridhar, who is an associate at Queen Emmanuel, Paris. And we have Ms. İpek İnce, who is an associate at Gedik and Eraksoy, Istanbul. Members of the panel, the floor is officially yours. And we would like to start the session by understanding that how important is the source of energy when it comes to environmental disputes. And for this, I would like to invite Mr. Akshay Sridhar to share his views. The floor is yours, sir.
Thank you, Arijit. Thank you for the very kind introduction and, of course, the invitation to speak here. To answer your question, there are first two things that we need to consider, especially in the backdrop of any investment arbitration. First is, what is the task of an investment tribunal? And how does that task overlap with environmental issues or environmental disputes? So to start with, what is the task of an investment tribunal? They have, just to put it simply, one simple task: to apply and interpret the very instrument which constituted the tribunal. That is, to apply and interpret the investment treaty. But keep in mind that an investment arbitration is essentially between an investor and a state, and an investor is not a signatory to the treaty. The investor is a beneficiary of the treaty. So from an investor's perspective, what exactly is the function of a treaty? And in pretty much layman terms, a treaty is like a rule book on state conduct. From an investor's perspective, a treaty is essentially a set of rules which tells the state how to treat the investor, how to treat the investment, what actions to take and what not to take. So essentially, the task of any investment arbitration tribunal is to assess that state conduct and see if it's a violation of the treaty in question and if it's a violation of any principles of international law. Now, how does this fit in with environmental disputes? First, just a broader point. when we speak about environment, and most certainly in legal disputes concerning the environment, it's certainly not just climate and energy. There's a whole bunch of environmental aspects. In fact, and I'll give you a few examples shortly, some of the most interesting jurisprudence on environmental issues in investment arbitration actually comes from mining disputes. So how exactly does investment arbitration and environment overlap? I think the answer to this is simple. Looking at the most common ground for an environmental claim or an investment claim, consider expropriation. The assessment of state conduct is done as per a certain set of criteria in a treaty. And some of the most important criteria to say analyze whether or not an expropriation, or should I say unlawful expropriation, has taken place is if the expropriation was carried out in furtherance of a public purpose, if it was done in a non-discriminatory manner, if it was accompanied by prompt and adequate compensation, and if it was done in violation of any rules of international law. So the idea here is simple. If environment or environmental issues are driving state conduct, they're driving state policy, quite certainly an investment tribunal may have to deal with that specific issue which underlies the state conduct, because it is the task of an investment tribunal to assess that state conduct. Consider some cases in the mining industry that I just mentioned briefly before. One that comes to mind is a case, Clayton v. Canada, where there was a dispute in Canada concerning a quarry. And essentially what happened was Canada gave out a license or a permit to construct a quarry and to mine from the quarry. And there were environmental concerns relating to the quarry. And eventually an independent panel was set up. And what the panel found was that there was an environmental issue with respect to the operations of the quarry, and therefore the project was rejected. The investors sued Canada, and in fact, the investor won the case in this particular instance. Now, one might think that this is simply a preference for the tribunal, in clear terms, that they are preferring an investment's protection over the environment, but things are often not that simple. If you dig in a bit deeper, what you see is that investment tribunals are not just assessing the content or the rationale behind a state's decision, they're also assessing in large parts how the state took that decision. So consider another case, and this one is in fact very interesting, Eco Oro v. Colombia. Eco Oro was an investor in Colombia, and what was essentially happening, to put it very briefly, their investment activity was interfering with a very beautiful, naturally occurring ecosystem in the Andes mountain region called Paramo, which is in the mountain range. And ultimately, a lot of tussle took place between the government and the investor and the courts. But ultimately, Colombia decided to reject the investment project of Eco Oro because of the damage it was causing to Paramo, the mountain range, the mountain ecosystem. When the investment tribunal was seized of this issue, you can see from the decision that it struggled to balance, on the one hand, legitimate environmental concerns of the state, and on the other hand, legitimate concerns of the investor as to how the decision was taken to reject the project, whether there was arbitrariness, whether there was fundamental unfairness, and whether there was discrimination. So these issues are not simplistic as to whether or not an environmental issue versus an investment's protection can be assessed on the same scale. But at the same time, and now zooming in a bit to your question, how important is the source of energy? By now, it should be obvious. It's not the key practical consideration before a tribunal, but the source of energy, and especially looking at recent cases, can often tell you how your potential investment claim before a tribunal will be phrased. Now, you have two different kinds of disputes, broadly speaking, these days concerning energy. One of them, of course, is the simplistic phase out disputes. You have, let's say, cases where Netherlands, for example, introduced recently a legislation for coal phase out. So what essentially the government of Netherlands is trying to do is get rid of coal production altogether by the end of the decade. And of course, any investor within the territory of Netherlands that has invested in coal or coal power plants could arguably have a legitimate ground of claim for destroying their investment. On the other hand, as perhaps all of you have heard about this, is the whole set of feed-in tariff cases in Europe, where there were a bunch of cases filed against Spain, Italy, Czech Republic, for what was essentially the state's revocation of assistance, so to speak, subsidy or guaranteed tariffs promised to producers of renewable energy. The first example is a bit more closely related to the environment, because essentially the purpose of the measure there is to simply protect the environment, and therefore the legislation comes to be. Unfortunately, none of these cases, at least to my knowledge, have been decided, and the one very famous nuclear phase-out case, Vattenfall, was settled. So we don't have instructive case law on this. But on the other hand, we do have many decisions on cases concerning renewable energy and feed-in tariffs. What these cases tell us is that tribunals often have not reviewed environmental issues, most certainly not because these were at the heart of the dispute, but simply because states didn't even seek to argue them. The key concern before tribunals in most of these cases was whether or not, for example, there was a legitimate expectation that the investor had to have the guaranteed tariffs continue for 20, 30 years or not. So in a nutshell, it's often that when state conduct is assessed by an arbitral tribunal, you often see not just what the decision is, but how the decision was carried out. What were the fairness aspects of it? And by the end of it, you see that, and I'm afraid to say this, environmental concerns don't often find that much consideration. But that said, I'd like to sort of end my answer, or rather protracted answer, on a good note. We have now seen a lot of new investment treaties, and a recent, I think OECD issued a survey recently which said that about 90% of new treaties are including wording on protection of the environment. So the solution is simple. The solution is not for investment tribunals to undertake the task of substantively trying to seek environmental protection, but for states, in fact, to agree to such obligations. We are, of course, seeing development of customary international law through the signing of multiple treaties. But at the end of the day, I think it's for states to agree to good treaties so that tribunals can properly interpret them one way or another. I hope that in some way I have answered your question, but I look forward to some further discussion.
Thank you very much. That in fact did answer the concerns and questions. And with this, since you mentioned about treaties, taking it up from there, I would like to point out the most important, or perhaps the most important treaty, which is the Energy Charter Treaty, which has recently been going on a series of modernization. And with this, I would like to invite Ms. Nevena Yevremovic to share her insights about the modernization process and about the kind of information which is available and what changes are we expecting out of the modernization process, which a few people believe will be concluded in a few months from now.
Thank you very much, Arjit, and the whole organization team for inviting me. It's such a pleasure to be here virtually and share the panel with such distinguished speakers. And I look forward to this and further discussions in the next 45 minutes. Arjit, as you mentioned, the Energy Charter Treaty is particularly relevant, and as previous speaker mentioned as well, actually, most of the feed-in tariff cases, especially against Spain, Czech Republic, and Italy, occurred under the ECT framework. So it's worthwhile to understand where ECT stands at the moment and what is the modernization process, or what is the goal of the modernization process, to understand if this balance between protecting foreign investments and foreign investors, and at the same time achieving climate change goals as set out in international instruments such as the Paris Agreement and the Glasgow Pact, can in fact be achieved. So in case someone in your audience is not that familiar with the ECT or the modernization process, so ECT came about in 1998, and it's a multilateral treaty that is focused on protecting investments in the energy sector. And as it currently stands, the ECT does not differentiate between fossil fuel-based energy and non-fossil fuel-based energy. And that has been a point of concern since it's, at least according to some critics, ECT as it currently stands, in fact, can be a barrier for states to achieving their net neutrality goals and their efforts in combating climate change. So in 2017, at the Energy Charter Treaty Conference in Ashgabat, the contracting parties decided it is a good time to review the treaty and see if the treaty can be aligned with these global efforts in combating climate change. Until today, we have had 12 negotiation rounds. Last one ended in April, and the 13th negotiation round upcoming in just 10 days from now. And the expectation is that the contracting parties will meet for the Energy Charter Treaty Conference on 24th of June and have an agreement in principle on the outcome of these negotiations. Now, what is particularly relevant here is that this negotiation process is not transparent, as we are used to seeing in the Ancestral Working Group 3, for example. So we don't really know the full extent of the discussions and the positions of the contracting parties, depending on what is at the table at the moment. Of course, the European Union, that has been very vocal in this process, has released the text of their proposal, and that proposal has also been subject to some criticism and scrutiny, but we can kind of, at least from that and from the information, kind of the summaries that are available on the official website, deduce what kind of changes can we expect. So to your question on the source of the energy projects or the energy investments, a particularly important proposal, also kind of chaperoned by the EU, concerns that definition of what type of definition of the economic activity in the energy sector, as well as the definitions of energy sources and materials. And in a nutshell, the idea is to kind of allow for a gradual phase out of protections offered to fossil fuel-based investments until 2040. So the idea is not to kind of get rid of everything at one go, but rather to kind of have that gradual phase out of protections. And that the text of the proposal is quite detailed, and it really depends that the extent of the phase out depends on what on the investors themselves, on the extent of the pollution and CO2 emissions and so forth. And the idea is to kind of deal with the major polluters first, and then kind of gradually move towards lesser polluters. What we see in terms of defining economic activity in the energy sector is that a point in discussions is this principle of flexibility. In other words, allowing contracting parties to adjust and determine their phase out process based on their own energy needs and kind of totality of the circumstances. So even if we do have an outcome on this, so an amendment of these definitions in the final text, it will likely be something more of a compromising nature, in the sense that contracting parties will have more flexibility in determining how they will they will go about kind of phasing out those protections. And one might expect quite different approaches, because if you take a look at what is the approach currently at the negotiation table in terms of the overall goal of the modernization process, the EU, for example, is quite firm, for a lack of a better word, that the modernization process, that the modernized treaty should align with green transition and green energy sources, whereas you have contracting parties such as Japan, which take the opposite stance. And also at the negotiation table, there are a lot of countries that are heavily dependent on fossil fuel-based energy. So it will be interesting to see what will be the outcome of these of the negotiations on these points. Now, these negotiations concerned on kind of changing what is in the treaty, and I'll just briefly mention that there have been also proposals to add provisions in the treaty that are not there as it currently stands. And that is a provision, a standalone provision on a right to regulate that would allow contracting parties to regulate in the interest of not just kind of public health, but also environment and climate change, and also a standalone provision on sustainable development. So again, those can also, taken together with those definitions, kind of give more a more comprehensive framework within the ECT on favoring or offering a differentiation, a clearer differentiation between non-fossil fuel-based investments versus fossil fuel-based investments. And with that, I'll stop here and say, you know, we will see what the outcome will be after June.
Thank you very much once again, Ram, for sharing your insights. You did mention about how tribunals particularly act and what kind of considerations are attached to all the proceedings which go on. This brings me to a point of concern. And as we have seen, and as you even pointed out, that ECT tribunals have typically ignored the source of energy. And even in one of the awards from a couple of years back, Blasphemy versus Italy, we did see that the tribunal decided that it was not an obligation of private investors to ensure they were minimizing harmful effects to environment. So this, I would like to invite Mr. Karthike Mahajan to share his insights as to what possible impact this award may have on tribunals who are situated similarly in dealing with similar disputes in the near future. Sir, if you may.
Sorry, Arijit, I actually had disturbance listening to you because there was some problem with my Wi-Fi. Could you please repeat the question?
Certainly, sir. Just before I repeat, I just wanted to make sure if I'm fairly audible at this point of time.
I think now you are to me.
Yes.
I think it was at my end. I'm sorry, I'm actually operating out of a hotel room right now, so which keeps on having his Wi-Fi go on and off. So if I'm not audible, please do interject.
Sure, I'll make sure I do that, sir. So what we wish to you to highlight that there was this award in Blasphemy versus Italy, where the tribunal mentioned that the private investors did not have any obligations to take such steps so as to reduce the harmful effects of environment in the host state. What do you think this award, what kind of impact it may have on future awards which may deal with a similar set of facts?
Thanks, got it. Thanks. I mean, I actually differ from that reasoning. I'm not sure whether the tribunal in the Blasphemy case actually ended up adopting that approach. I think when we look at investment treaty awards in general, we have to look at the facts in which those awards were given and what was the rationale for the tribunal to state X or Y. Let me give a little bit of background on this case. In this case, basically, Italy had, like many other European countries, given incentives for people to come up with renewable energy projects. In this case, the specific tariffs for solar power were the incentives in play. The investor was mandated to come up with 120 megawatts of solar photovoltaic cells for solar energy. There were 120 distinct 1 megawatt cells which had to be combined together and patched together as one unit. The incentives were suddenly taken away by Italy, and they were not being implemented, because of which the project never took off. It created a sense of legal insecurity, in the words of the investor, because the legitimate expectations with which it had invested, something which Akshay alluded to in his opening speech, were not being there. And this is the most common ground that you would see across the solar claims, or generally claims in relation to renewable energy, whichever is out of Europe. In that sense, the tribunal had made an observation that when it comes to the investor did not engage in an EIA, but there was no requirement to undertake an EIA, which is environmental impact assessment, because the Italian law did not mandate it. Now, when you look at the treaty, which was the ECT in that case, it basically said that the investor, which is also the usual obligation which comes across in BIDs, has to comply with the domestic laws. The domestic laws in that case did not provide for an environmental impact assessment. And that is the reasoning which the tribunal ended up adopting. The tribunal level said that, when it comes to all future cases, or when it comes to cases in general, you cannot have regard to environmental protection. In fact, to the contrary, the tribunals are increasingly suggesting that environmental protection is an important aspect of your investor protection, and the investors have to comply with environmental standards. And I will possibly allude to it, as this webinar progresses, as to how the protection of environment is becoming increasingly important. But just to go back to the ECT and aspects which talk about environmental protection and which would stand as it is, irrespective of this award. If you look at different standards, if you look at Article 19.1 of the ECT, I'm just going to read briefly about it because I have the ECT open in front of me. It asks the investors to take into account environmental considerations throughout the formulation and implementation of their energy policies. It asks the investors to promote market-oriented price formation and a fuller reflection of environmental costs and benefits throughout the energy cycle. It also encourages cooperation in the attainment of environmental objectives of the Charter and cooperation in the field of international environmental standards for the energy cycle. So what I'm trying to say is, it's not that the ECT is dehorse environmental protection. It's just that what ECT mandated in that case, which the tribunal reason was that you have to comply with domestic laws, and since domestic law doesn't provide for an EIA obligation, you are not supposed to undertake one. So that's why I think the way I pitch it is that this award is limited to complying with domestic laws, and whatever is required under the domestic laws with respect to environmental protection, it needs to be strictly complied with.
Thank you so much, sir, for clarifying the case and its facts, and also presenting your view as to what is the correct way of going about it. With this, I think I would like to take a step back, and I would like to come back to another point which was highlighted by Nevena ma'am when she was explaining to us the scope of ECT. And there is this scope, or there have been concerns primarily in the academia and among some practitioners, that while the ECT does have certain provisions which are exhaustive or even broad, the ECT has so far not been read along with other laws or agreements concerning climate change. So we would like to understand whether there is something in the ECT which prevents ECT being read with other conventions, or has it just been the approach which has continued for so long, which has prevented the tribunals from taking a more broader view? If you may now, ma'am.
Right. Thank you very much. So I'm kind of reluctant to take a very general approach in answering that question. So I'll start off by looking at what we have in the ECT as it currently stands, and then look at some of the review of the awards that have been rendered under the ECT to maybe help us understand where tribunals in generally in what directions do they generally take. Again, really, as Kartikeya mentioned, it depends on the case, on the facts of the case, and on the specificities of the case. So it's not black and white situation. So the ECT, in fact, has a provision that requires the tribunals to interpret it in line with the international rules that are in line with the international rules. And also we have that obligation under the Vienna Convention on the Law of Treaties that requires that any treaty is interpreted in line with rules of international law, or in line with international law. But when and in addition to this, I mean, the ECT itself has provisions on sustainability, on environment. It has a reference on UNPCC. So when you look at it as a whole, you would say that there are actually more incentives to apply the obligations or the standards of investment, the standards of protection of investments in the ECT along the lines or along the side of other obligations on climate change and international agreements on protection of environment. Nonetheless, what is present in practice, and has been alluded by previous speakers, is that that is not often the case. So often academics and practitioners say that there's this reluctance of applying or interpreting standards of protection in line or alongside, or kind of taking a holistic approach with obligations under international agreements for environment protection or climate change. So to take an example, the latest report of the report of Climate Change Council, they have reviewed 64 awards as they have identified to be relevant, and 20 out of those were related to fossil fuel, but in no case was there a reference to climate change, international climate change framework. A large number of the cases were in fact these feed-in tariffs or regulatory cases. And there are some interesting kind of movements there. So for example, if you look at the Spanish cases, when Spain first introduced incentives to kind of boost their renewable energy sector, that initial line of cases was rendered generally in favor of Spain, saying that Spain had a right and that there was no violation of the standards of protection under the ECT in introducing those feed-in tariffs. But when they decided to take away those incentives, as was happened in Italy, then that's when the tribunal started interpreting it as saying, you know, well, that would be a violation. Interestingly, Italy kind of withdrew from the ECT, where Spain still, although it's the country with the highest number of cases, still is a contracting state. So why the tribunals take this approach would really require kind of a deeper dive than we already have in all of these cases. What we might see in the future, or some changes in this respect, might come with the modernization process. So to address some of these concerns, for example, the introduction of a special provision or a standalone provision on sustainable development, the current proposal references to international agreements, to relevant international agreements, and just bear in mind that sustainable development is almost an umbrella term, if you will, covers both climate change, environment protection in all of its elements, so biodiversity protection of wildlife and so forth, but also social and economic aspects. So it's a very broad term. And then in addition to this, there's that right to regulate, so that the states have a right to enact national legislation that is in line with kind of protecting the environment and combating climate change. Now, that's the proposal. What will be the outcome? That is still that is still to be seen, but the current proposal that stands is, at least according to some, the most that we can expect at this stage. And it really would give the tribunals what they need in kind of through interpretation of the ECT, find that balance between protecting investors and their investments versus the state's right to regulate and kind of maintain their other obligations, you know, on an international, regional, or national level. So I hope this answers the question.
Thank you so much for sharing your insights on the same. And yes, it did clarify the situation as to why the tribunals do it. And with this, I would now like to invite my co-moderator, Sanjana, who would be taking forward from here and would now dealing with future prospects of what may change in the field of international investment law. Thank you so much.
Well, there is one question that I would like to address and request Ms. Ipek and Mr. Andreas to address regarding the Green Pledge, which, and I wish to gain their thought process on the same, that is the Green Pledge, though not related to investment arbitration, has taken a significant step towards ensuring greener arbitration. So how can a simpler pledge or framework aid arbitrators in determining commercial as well as investment disputes that have been associated with the environmental concerns? Basically, under this point, we would request your contribution to acknowledge the Green Pledge, which is not related to actually investment arbitration, but we would request the panel to discuss whether it is possible for us to see in a foreseeable future that a similar kind of pledge is drawn to assist the investment arbitrations and to not just make the proceedings greener, but also invoke certain considerations for the tribunal as well as the climate. Ma'am, sir, if you may please.
Thank you very much. Thank you, Andreas. Maybe first I can start by clarifying two common misconceptions. First, my name is Pronazet İpek İnce, and the second is Campaign for Greener Arbitration is actually not designed to address environmental concerns in particular type of arbitration proceeding, whether it be investment, commercial, or construction, you name it. Green protocols introduced under the Campaign for Greener Arbitration is actually involves green steps every player in arbitration community can implement in their everyday legal practice. So having said that, maybe I can first start explaining what Campaign for Greener Arbitration is, and then let Andreas follow up with what we can do to tackle with environmental concerns involving arbitration proceedings, if that's okay.
Like a plan.
Perfect. So Campaign for Greener Arbitration first started in 2019 by Lucy Inwood. Lucy published a post in her website in 2019 saying that from now on in the arbitration proceedings where she is in the panel, she will regard the environmental concerns, and that post is now called as the Green Pledge. And after that post, Green Pledge called the attention of the wider arbitration community, and soon hundreds of people also sign up to the Green Pledge and promise to regard environmental concerns in how they run their arbitration proceedings. And then the Green Pledge became an initiative around 2020. And the Campaign for Greener Arbitration is officially established. In the campaign, we aim to reduce the environmental impact of every international arbitration proceeding. This can be investment or commercial arbitration, and promote awareness in the arbitration community as to the carbon footprint and our play in the carbon footprint we incur in arbitration proceedings. In order to achieve whole campaign has two main instruments. First is the Green Pledge, and the second is Green Protocols. As I said, Green Pledge is a public commitment to minimize environmental impact of our daily legal practice. And by visiting Campaign for Greener Arbitration's website, you can actually sign up to the pledge, either as on behalf of your firm, your arbitration institution, your university, or individually. And by that, you will publicly make a commitment to take gradual steps toward more sustainable future. And the second instrument we have, Green Protocols, are guidelines that outline the concrete steps that each member of the arbitration community can take to reduce impact of each and every arbitration upon the climate. Currently, as I said, we have 5 protocols, each tailored for different actors in the arbitration community, namely arbitration institutions, law firms, legal services, centers such as arbitration hearing centers, etc. And we have one general Green Protocol, which is a general protocol address arbitration proceedings, and there you can have a model procedural order that you can directly implement in your procedural order number 1, either wholly or partially. When you visit our website and read the Green Protocols, and I'm happy to announce that now Green Protocols are available in 5 languages, you will see there are lots of steps that you can take to make your arbitration proceedings more greener. And I will not be listing all those steps for the sake of the timing, but maybe a key steps that everyone should take is first being, of course, virtual hearings. You can enjoy hearings at the comfort of your home and or your office as much as possible, and by that you will be helping to run more green proceedings. Second, e-bundles are a great way to reduce our carbon footprints. If you have a Kindle, or have you ever considered buying a Kindle, you can very well do with e-bundles as well. I personally use it and I find them very helpful, especially in virtual hearings. And in case you cannot convince your partner or your client to implement green protocols in the arbitration proceedings, then you may consider offsetting your carbon emission incurred during the proceedings. You can do that in many ways. You can make donations to the charities, green charities. You may plant some trees, etc., in order to offset the carbon emission you incurred during the arbitration proceedings. And you can find the further details on, as I said, Campaign for Greener Arbitration's website. And I hope you will sign up to the Green Pledge today after this webinar. Over to you, Andreas.
Thank you so much, Ipek, for providing an overview of the Green Pledge, because this is part of the question of Sanjana. Maybe before I start, I just want also again briefly to thank for the kind invitation to this webinar, and it's a big pleasure to be here. Maybe I have to say that the question which is in the room, whether a green pledge could also be used on substance, is not a straightforward one. And this is maybe just to give 3 points why it is not a straightforward one. Is first, how would the substance of such a green pledge, how would this be defined? Would it just be that, sustainable development should always prevail over non-sustainable development, or should it be more precise? And if we have this first version, this very, very broad one, then it's questionable whether it actually helps a tribunal over maybe a treaty text or whatever. And when it's more defined and more precise, when we go into industries and so on, then it's less likely to be applicable in a present case. Then second, the green protocols, or the green protocols which Ipek mentioned, you can describe them as soft law. It's not a binding law. unless the parties specifically agree on them. And you can imagine when we have an investor and a state, and the investor is a coal producer or has a coal plant, it's very unlikely that the investor will agree to the applicability of such a green pledge, which actually favors rather the state and not the investor. And the third point is going hand in hand with that one, the incentive to agree on such a pledge. And when there is likely no incentive to sign it, there is also likely no incentive to draft such a green pledge. But no worries, I will not leave it there and just say it's difficult. I will try to find a potential answer, and this webinar is mostly on investment law, and I try my best. I'm a hardcore commercial arbitration lawyer, but I could maybe think of something in that regard. So as many of the previous, or each of the previous speakers has mentioned in one way or the other, that BITs originally were rather one-sided, and they were in favor of the investors. Actually, they were designed to attract investors to states where they usually would not invest, and that's why they would rather benefit them and not laying obstacles in their ways when they want to invest in a country they usually would not. And after maybe these BITs, as many started, I think, in the 60s, 70s, and then they developed more and more. And then this is now very, very general, right? But human rights concerns became stronger, environmental concerns became stronger in the last 2 or 3 decades. And that's why they were more and more criticized, and that they were only favoring the investors, and they were not looking at negative effects of investments on human rights and environment. And there was more and more a consensus that there needs to be some rebalance in that respect. So, and I think that goes to the core. In investment arbitration, mostly you look at the treaty. So the treaty text, also the specific treaty and the specific provisions which are in this treaty are the basis for any decision of the tribunal. And most bilateral investment treaties, they include not hardcore obligation today for the investor to make sustainable investments. But what you sometimes have is preambles, especially in new generation bids. You have preambles which say that generally the state is empowered or has a right to favor public policy or its public interests when it's about sustainable development, human rights, and so on. So when you have maybe a treaty provision which is unclear, you can make a connection to the preamble and then say in a systematic interpretation that you should give more weight to environmental concerns. That's one way. Then sometimes you have carve-outs. So states say in particular areas, in particular industries, we want to carve out where we want to be free to legislate and to regulate in the name of our public interests. And the third area, sometimes bids make a reference to also kind of soft law, from the United Nations or the OECD. They have also guidelines, for instance, the UN Guiding Principle on Business and Human Rights, or the OECD guidelines for multinational enterprises. And such a reference could also help to give more weight to the environmental aspects. Now, I think this was mentioned by Karthikey when I was right. When I'm right, that tribunals come up more and more with, they look at the source of the energy, and they say that environmental concerns should have a particular place in the interpretation of bids. And I think that's the way to go right now. So the interpretation, you see more and more awards where tribunals try to interpret the bid more in favor of the state in the name of environmental concerns. And for that, they try to not only look maybe at this particular provision, but to take other, like a reference to UN guidelines or to a preamble or to a carve out. So that's right now what is happening. And I think you, Akshay, you mentioned customer international law. So I think Article 38 of the ICJ statute, which is a major, it's a very important norm in public international law, and it basically describes what constitutes public international law. It could be when there are more and more words interpreted in favor of environmental concerns, that this becomes more and more accepted, and accepted practice. That's why it becomes customer international law, or falls under one of the other prongs of Article 38, which are general principles of international law, or that judicial decisions can also form basis of public international law. And maybe once this is more and more established, then the states will also do it then in writing. They will insist that in the treaties, this is also written there and clear. So this is, I think, how you have kind of a green pledge on substance, but via a totally different way. So that's on investment law. And then maybe very briefly on commercial arbitration, there is increasing pressure on companies in commercial life to comply with environmental standards. And this has many reasons. One is there is a lot of activism going on. I mean, we are part of this activism. This is also a good thing. And the second one is that the market demands sometimes, funds have to show that they don't invest in weapons or in coal. So the market is the second. And the third one are state court decisions like Shell case and so on. So there is an increased pressure on companies to comply. And the regulators also are taking up speed. And there are more and more compliance guidelines which say that the companies have to disclose, how they invested their money. Is it green or not? And there is an idea. I mean, if the regulator can do that on the substance to disclose and force the companies to disclose, then the regulator could also say any disputes which are conducted between companies should also be green. And that's why the green protocols could maybe gain more momentum in the future. So that's my take on that, and I hope at least partly it has answered your question.
Thank you very much, sir and ma'am, for sharing your insights on the Green Pledge. With that, I would address a general question to all the panelists, and I would request them all to share their comments and observations on how to balance carrots and sticks to ensure environmental concerns are not overlooked in the field of energy or environmental related disputes. This is for all the panelists. If any one of you would like to share your insights on the same.
Sorry, I'm very sorry. What was the question, Sanyana? Sorry.
Yes, sir. So the question that I addressed was how to balance carrots and sticks to ensure environmental concerns are not overlooked in the energy or environmental related disputes.
Okay, thank you.
I don't mind going first. I think for me, the simple answer is I don't think it is getting overlooked at all. And I can, say that very safely that any tribunal would dare not ignore it anymore. Because the increasing trend, if you just look at the number of awards, I was just looking at these statistics before this talk, and it was quite interesting. Like prior to 2000, I think there were just hardly any awards which dealt with environmental concerns. From 2013 onwards, there have been 60 awards, which just shows how much of a significance environment has taken in terms of the deliberations of the tribunal and what they're looking at. So I personally don't think that the tribunals would be disregarding it. I think when it comes to energy environment, what might be useful is that before even the dispute matures, or when we even talk about what the tribunal should do, I think the best thing is if a lot of arbitral tribunals end up coming up with some rules which are more environmentally tailored, something on the lines of what PCA has done. Because if the arbitral tribunals themselves come up with such tools, what it does, it helps give more incentives and more armory to the tribunals to rely on those tools and then resolve disputes in a manner which is best suited for environmental interests. So I don't think anyone is ignoring it. I think what can even help is having more facilitative tools.
Thank you, sir, for sharing your insights on the same. If Akshay, sir, doesn't mind, I would request you to go next.
Thank you, Sanjana. Just following up from where Karthikeya left, tools to facilitate this. Two very interesting examples come to mind when it's tools in investment arbitration. The first is something that's actually getting more and more traction these days, is non-disputing party intervention. What you often have is in investment arbitration, the default position, as it is in commercial arbitration, is that there is privity in the arbitration. So only the two parties will have the dispute. But recently, we have seen a trend that non-disputing parties can also intervene in these disputes. And it has often happened, I don't have examples off the top of my head, but it has often happened that NGOs have intervened in exit cases. And the essential condition for any non-disputing party to intervene is that they need to assist the tribunal by providing a perspective different from the disputing parties. So even if the parties in dispute do not want to talk about the environment, there can be a legitimate interest for any environmental organization to actually intervene in the dispute and educate the otherwise unwilling tribunal about potential environmental concerns. The other tool that comes into mind is counterclaims. There has recently been an increasing trend also in states, responding states in investment arbitrations, to actually make a counterclaim against the investor. Now, there's a whole question about whether or not there is jurisdiction over a counterclaim and whether it's even admissible in the first place. But it is interesting to look at one of the awards, a very famous one, Perenco v. Ecuador, where actually Ecuador made a counterclaim against the investor for actually seriously damaging the oil block concessions that it had undertaken as part of its investment activity. And interestingly enough, the counterclaim was awarded to Ecuador for a value of about over 50 million. It's a different story that eventually even the claim was granted, which went further than 400 million. But the principle remains. There is now jurisprudence that investment tribunals have awarded environmental counterclaims to states. And that certainly should be kept in mind both by the community going forward and also investors when it comes to them making claims before tribunals.
Thank you, sir, for sharing your insights on the same. If Navena ma'am could go next and share her thoughts on the same.
Yes, absolutely. Thank you. So I'm going to play devil's advocate here and say I'm less optimistic than the two previous speakers. For every pro-environmental or pro-energy case, if you will, there are at least two that are not pro-environmental or pro-energy related. So I think it will really depend on several circumstances. So the language of the BIT, or of the trade and investment treaty in place, how the tribunal sees their task in a given scenario. So, for example, in Eco Oro that Akshay mentioned at the beginning, there was language in the in the trade and investment treaty that was applicable there that allowed for the state kind of taking measures that are that are aimed to protect the environment, and yet the tribunal still found that the investor has a right to be compensated, and that decision was heavily criticized because of the stance and kind of the reasoning that the tribunal took in that place. So as long as we have these kind of exceptional cases, it just signals that we are not really on the right path in terms of how to reconcile and balance these interests. So the procedural tools that Akshay mentioned, I absolutely agree. Amicus curiae, or participation and interventions of non-disputing parties, and the state's right to counterclaim will be essential. From my perspective, more clarity and guidance is necessary to ensure that these non-disputing parties can in fact participate, or that the state has a right to counterclaim. So some of the recent BITs include, for example, express provisions on counterclaims, and the recent changes of the ICSID rules also kind of lessened the requirements for non-disputing parties to intervene in proceedings. And then the second part, of course, will be providing more clarity in the text of the treaties on the standards of protection, so FET carve-outs, and defining investors' obligations, and so forth. So it's still a lot of work in progress, and a lot of reform happening on different fronts. So we will see how and where that leads us. So I'm sorry that I don't have a definitive answer for you, but those would be my thoughts on this.
Thank you very much, ma'am, for sharing your thoughts on the same. I would now request Andrea, sir, to go next and share your comments on the same.
Okay, thank you so much. And maybe I still have to ask the question, because the carrots. Who are the carrots for? Carrots and sticks. From whose position? Who are you addressing? The arbitrators, the states, the investor?
So it's just a phrase that we use. We are actually addressing to the states and investors in a general perspective.
I see. So from the state's perspective, it's anyway interesting to have more environmental friendly provisions, I think. And I think maybe they should be more courageous. And from the investor side, I think there is a bigger market than in the past years in renewable energies. So maybe there is a bigger incentive to sign more progressive bilateral investment treaties. But more in detail, I struggle a bit to come up with a good answer. Thank you.
Thank you very much, sir, for sharing your insight. I would now request Ms. Ipek to continue and conclude the discussion on the same. I apologize for the pronunciation earlier.
No problem at all. It's a very common mistake. I know that Turkish names are not the most popular names around the world, so no worries about that. Maybe I can conclude by sharing a personal story. A couple of months ago, I had a meeting with one of the biggest corporations in Turkey, and during this small chat phase, I just told their head legal counsel that, oh, I recently heard that you announced net zero carbon emission goal by 2030. So how did that affect the legal department? What changes did you introduce, etc.? And he turned to me and said, did we? And I find it very strange, because that company also recently issued an ESG bond, which they should be very curious and very careful about their environmental impact as the company. And a couple of weeks later, I received an email from that head legal counsel saying that they recently had an intercompany meeting where the management asked a report from every department as to what green steps, let's say, they have taken since they announced the net zero carbon emission goal. And they also introduced an incentive program for each department. If they, for example, take certain steps and reduce their carbon emission to a certain extent, they will be incentivized by like some financial awards, some bonuses, premiums, etc., so that the company can reach their goal by 2030. I think that's an amazing example of how companies can address environmental concerns, and this is how we can invite legal practitioners in the companies as well to be part of the change.
Thank you so much, ma'am, and thank you so much, everyone, for sharing your insights and presenting different perspectives on what has been a hot discussion over the last couple of years. I thank once again each one of you for accepting our invite and adding to the discourse of this topic, which I'm sure is going to be there at least for the next couple of decades. So we are going to have continuous literature and discussions on the same. And we do hope that our paths will cross again. With this, I would like to formally conclude the session. And I thank the audiences who joined us through YouTube Live. And as for the questions they had asked, I see each one of the points covered by every single panelist have already addressed those points. Therefore, I would not be going into the questions again. And with this, I would now like to formally conclude the sessions and thank each one of you once again last time for joining the session. So thank you so much on behalf of our university and our alternative dispute resolution cell. And we do hope that we get the opportunity to host each one of you in person at our university when things turn a bit more normal, hopefully in a few months to come. Thank you so much and have a great day ahead to each one of you.
Thank you so much.
Thank you so much, Sanjana and Anisha.
Thank you, everyone.
Thank you to